Good afternoon, everyone. Thank you for joining us today, and welcome to the Victims, Witnesses, and Defendants with Intellectual and Developmental Disabilities Key Information for Prosecutors webinar. As I mentioned earlier, all of our phone lines are currently on mute mode, and we are recording the webinar today. For those of you that require closed captioning for this event, I've included the URL link on the right-hand side of your screen. If you have a question for us, please use the chat function on the right-hand side of your WebEx platform, and you can send us your question, and we'll do our best to address any inquiries you may have following our presentation. We want to let everyone know that the webinar presentation will be sent in a follow-up email, and we will plan to post the webinar recording as well. So we're joined today by the Serving Safely Initiative team, and to kick off our webinar, I would like to welcome Ariel Sims from the ARC.
Hi, everyone. My name is Ariel Sims. I am the Senior Program Manager and Attorney for Criminal Justice Initiatives at the ARC of the United States. The ARC is the nation's largest and oldest advocacy organization for people with intellectual and developmental disabilities. Specifically at the ARC, I work at our National Center on Criminal Justice and Disability, or NCCJD for short, and one of the things we do is routinely provide training and technical assistance to a variety of justice professionals, including prosecutors, on serving and interacting with those with intellectual and developmental disabilities. And I am so excited to be here with all of you and with my co-presenters, and with that, I'm going to turn things over to our next co-presenter.
Dean Hammond. I'm the Executive Director of Prosecutors Center for Excellence. Before this, I was a career prosecutor at the Manhattan District Attorney's Office in New York City. Prosecutors Center for Excellence is a team of prosecution experts that work on best practices, innovations, and implementing solutions to the many difficult issues that prosecutors face today. Melissa?
Hi, this is Melissa Royland. I'm working with the Vera Institute of Justice, and Vera is working on addressing policies around the intersection of people with disabilities, people with mental illness or IDD or others, and the criminal justice system. Our goal is to reduce the reliance, the over-reliance of law enforcement on punitive measures for these populations. Thank you.
And Melissa?
I'm going to go ahead. It's Melissa giving you an overview of the Serving Safely project. This project is funded by the Bureau of Justice Assistance. Slide. It's a national initiative that's a collaboration among many experts and partners in the field, including on this call the Prosecutors Center for Excellence and the ARC. Our work, as I say, is supported by BJA, and we're pursuing a number of ambitious objectives to meaningfully contribute to the field and bring tangible benefits to law enforcement and prosecution agencies. Over the past year, we've worked with over 50 such agencies across the country and have supported programs that allow safer interactions with people with mental illness and or intellectual or developmental disabilities. And this is the main goal of these collaboration programs. We've worked to support clear and effective communication between agencies, mental illness and IDD service providers, as well as community stakeholders. We know that building and sustaining partnership is a key to programs. We also work on enhanced partnership strategies and models for referrals to professionals and community supports rather than jail whenever appropriate. It's also important that we work on the destigmatization of mental illness and IDD across agencies and the community through training and education, as well as partnership building. We work on improved planning, deployment, tactics and training, and other operational priorities through the use of data and technology. In addition to working directly with agencies, both police and prosecutors, we are also developing products for the field, producing webinars such as this one, and developing a research agenda to identify the gaps in the research base and suggest what future research is needed This is particularly important in the space of intellectual or developmental disabilities because so little research has been done to date. Ariel?
Thanks, Melissa. So as Melissa mentioned, the Serving Safely initiative is really designed to help justice professionals, and specifically law enforcement and prosecutors, better serve, understand, and interact with people with both mental health disabilities and developmental disabilities. But on today's webinar, we're really going to focus on developmental disabilities. And sometimes you'll hear me say intellectual and developmental disabilities, or sometimes IDD. I'm referring to the same kind of category of disabilities. Now, just to be clear, developmental disabilities are not the same thing as mental health disabilities, and prosecutors, like many justice professionals, tend to be more familiar with mental health disabilities, things such as depression, psychosis, bipolar disorder. These are kind of common mental health disabilities, but not what we're talking about today with developmental disabilities. So I'm going to start by just giving you a few clinical definitions, both of kind of the category of developmental disabilities, but also some of the more common developmental disabilities you might be more likely to encounter as a prosecutor in your job. And the characteristic of these definitions will be a bit more clinical. And the reason I'm using some clinical definitions is that these definitions are really important when trying to get somebody into services, for example, and they're often the definitions that many of our laws rely on. So we're going to go over some of the clinical definitions, but then I'm going to give you sort of a shortcut, a way of thinking about developmental disabilities that hopefully won't feel so clinical and won't make anybody feel like they're trying to diagnose anybody. One other thing I would just say is that disability is also an identity. So even though we're going to be using some clinical terminology, it's important to remember that disability is part of human diversity. It's part of what makes us who we are as human beings. So kind of keep in mind throughout that we're also thinking about disability as a form of identity. So I want to start with sort of the umbrella term, if you will, and this is probably the easiest way to think about developmental disabilities. So there are lots of individual diagnoses, labels, things that will fit under this umbrella term of developmental disabilities. So what are we talking about when we say developmental disabilities? The clinical definition is that they are physical and or mental impairments that start before age 22. So this is where we get the name developmental. It really starts during a person's developmental period while they're growing up before they even become sort of a full adult. But in addition to that, we have to have substantial functional limitations in at least 3 of these areas. So the ability to care for oneself, the ability to learn new things, to walk or move around in maybe a way that we would think of as typical, to direct one's life, make decisions about one's life, kind of decide what you're going to do and be, to live independently and to support yourself as well, economic self-sufficiency, and possibly also the expression of language and how you communicate with the world around you. Now, as I mentioned, this is the umbrella term, so there are lots of individual diagnoses and labels that will kind of fit into this bucket. And these are just a few examples, things like Down syndrome, Fragile X syndrome, cerebral palsy, autism, fetal alcohol spectrum disorder, epilepsy. These are all things that can fall under this broader category of developmental disability. And sometimes, too, intellectual disability falls into this category. And I have it highlighted there because this is also relevant for prosecutors who work in states that still have the death penalty. You may all know that or be familiar with the Eighth Amendment prohibition on executing people with intellectual disability. So that definition certainly comes up a lot when we're talking about criminal justice and developmental disabilities. So let's start with the clinical definition of intellectual disability and then kind of why it might matter to you as a prosecutor. So intellectual disability has 3 prongs, and the first prong, as you could imagine, has to do with intellectual functioning. And what this essentially means is that if somebody's taking a standardized IQ test, they're scoring below average on this test, but that's not enough to fit into this bucket, this category. You have to have some other things too. So the second prong are what we call adaptive behavior limitations or deficits, and generally these fall into 3 different areas. So conceptual, kind of your ability to reason, think through things. Can you, do math in your head, those kind of things. Social skills, do you understand things like social space and boundaries? Can you read sort of the unwritten rules of human interaction? And things like practical skills. Can you tell time? Can you use money? Can you navigate public transportation? Skills that we might use every day and not even think about it could be impacted if somebody has intellectual disability. And again, because we're talking about developmental disabilities, there's typically that age component. And for intellectual disability, we have a specific requirement of the onset of the disability has to be before the age of 18. So a little bit different in that developmental disabilities more broadly, it's before age 22. When we're talking about intellectual disability, it's before the age of 18. Now, the vast majority of people with intellectual disability will fall into the lower support needs category. And what this means is that it's going to be really hard to identify that somebody has this disability. You won't be able to just tell by looking at someone, but you might notice things over the course of an interaction that might lead you to think, this person might have a disability and might have this disability in particular, but it's not going to be necessarily sort of obvious upon the very first interaction with someone. Now, I want to move on to autism, and autism, I think, is one of the developmental disabilities that is probably one of the better known. A lot of people, if they know anything about developmental disabilities, they tend to know something about autism. And of course, it's very, very common for folks to have autism, and we're getting new and new statistics every day, kind of going up with the number of diagnoses of this particular type of developmental disability. So autism is a pattern of neurodiversity, and it can be characterized by a few different things, and I just wanted to give some highlights here. So one of the things that often comes up with autism is people might struggle with social interaction and reading social cues. So we talked about things like body language earlier. It might be very difficult for somebody with autism to read something like body language and understand what it means in the context of a social interaction. Some people with autism don't communicate verbally. They might communicate in other ways through gestures, through sounds, through other means of communication that are not typically verbal. And we can kind of see that on all sides. And we might also notice some things called repetitive behaviors. Sometimes we refer to this as stimming, which is kind of short for self-stimulation. So kind of behaviors such as flapping of the hands, maybe rocking back and forth, behaviors that tend to calm somebody down who might be experiencing some overwhelming feelings. And kind of this last bucket here, sensory processing difficulties. It's very common for people with autism to have a hard time kind of processing all the different kinds of sensory information that people process every single day. So you can imagine what it might like if you're having a hard time processing things like sound, noise, light, people interacting with you, touch. These things can pose some challenges for people with autism. Now, autism is really a spectrum, and so it includes people with a variety of different characteristics. And kind of one of the phrases we like to use in the developmental disability world is, if you've met one person with a developmental disability, you've met one person with a developmental disability. And it's important to keep that in mind throughout, that even though I'm giving you some of the basic characteristics or things that it might look like, everybody is different and experiences these disabilities differently. Fetal alcohol spectrum disorder. This is one that has not been as well known recently in the criminal justice context, but is sort of up and coming as we get a better understanding of just how many people were impacted by having a parent consume alcohol while pregnant, which is what can lead to FASD, or fetal alcohol spectrum disorder. One of the things that's so tricky about FASD is that people often have IQs in the average range, and so it's just really difficult to identify that somebody even has this disability. We often see difficulty with things like abstract reasoning and concepts, judgment, kind of understanding the consequences of one's actions, and impulsivity, which you can imagine those kind of three things together can very likely predispose someone to be involved in the criminal justice system. And then people with FASD, they often have very good expressive language skills. So even though they're impulsive, they may have some issues with judgment, they can often express themselves really well. So it's not, again, immediately clear that a person even has a disability upon first interacting. So I wanted to give you the shortcut. So I just gave you some of the clinical definitions of the kind of more common developmental disabilities and the ones we're constantly seeing in the criminal justice context. But here's the shortcut. I don't want anyone to think about diagnosis or trying to pinpoint exactly which developmental disability label applies to someone. Instead, I want you to take the functional needs approach. So access and functional needs, this is something that has been used for a long time in the fields of disaster response and emergency response because it kind of builds on the notion that you're never going to have enough information at your disposal to figure out sort of exactly what a person might need. But what you can do is kind of approach everybody the same way and think about what need does this person have in front of me. And I just want to give you some quick examples. So let's say you're interacting with somebody and you need them to fill out a form. And they pick up the form, and then you notice they're sort of squinting at the form, and you're like, my goodness, I think they might be having a hard time reading that form. And it could be for a variety of reasons, right? It could be maybe the font is too small, maybe the contrast isn't high enough, but maybe they need glasses and they didn't bring their glasses. There's a variety of reasons there, and what might be important to you is not so much the underlying reason that they're having trouble viewing the form, so much as the fact that they're just having trouble viewing it. And what you might do in that situation is say, hey, it looks like you're having some trouble seeing that form. Would it be helpful if I printed off a copy in larger font? Or if I read the form out loud to you? Or is there something else I can do to make that form easier for you to see and to interact with? So again, we kind of don't need to know sort of the underlying label, if you will. We can think about what the person might need and what we can do differently to help address that particular need. When we're talking about things like intellectual or developmental disability, a very common need that might arise is you might notice somebody has trouble understanding you. Maybe you're having a conversation, maybe you're interviewing them, maybe you're trying to explain something that's particularly difficult, and you're not quite sure if the person is following what you're saying, if they're really understanding. One of the key tools we recommend is a check for understanding. So you could kind of pause in your discussion and ask the person, hey, could you tell me what I just told you in your own words? I just want to make sure this is really difficult stuff. Could you maybe explain that back to me? And that's a really kind of simple way to make sure that the person you're interacting with is actually understanding. And sometimes what we find is if we sort of just ask directly, do you understand, we might get a lot of yes, even if that's not necessarily true. Now we can think about kind of the access and functional needs approach in a few different ways, and I want to make an analogy here to language access. So as prosecutors, you're part of state and local government, some of you are part of federal government, and you know that we have to provide language access for people who say don't speak English as a first language. And there's lots of reasons that we do that. I mean, on the one hand, language access is a legal obligation in many ways. It's also an ethical obligation. We can think about as legal professionals that we are trying to do the best job we can in our respective roles. And it's also just generally good practice. It helps us do our job better if we can really communicate with somebody effectively. So you can think about this in the disability context the same way as an obligation, but really it's coming from both a legal place and an ethical place, but also just all around a good practice. And really the key takeaway is that all of this is really meant to help us do our jobs better as legal professionals. Now, let's say that you're interacting with somebody and you're really not sure if they have a disability at all, if they have an intellectual or developmental disability. It's very possible, and I would say almost with certainty, that everyone has interacted with somebody with intellectual and developmental disability at some point in their life, and they may not have recognized it at the time or known at that time. So what I want to do is give you some general identification tips, general things that you can think about that sort of might hint that there is a disability. And again, it might then kind of trigger back to the access and functional needs sort of approach of what does this person in front of me, what might they need, and what could I do to maybe help them get there? And one other thing I'll say is that, people with disabilities don't necessarily have to disclose their disability regardless of how they're interacting with the criminal justice system. Everybody has things about themselves that they wouldn't necessarily want other people knowing about, and disability is no different from that. So there is no sort of kind of expectation that people disclose. It's possible they will disclose, but this will just help you think through when you might be interacting with somebody with a disability if they don't disclose that to you. So I want to divide these up into a couple of buckets. We're going to look at communication, behaviors, and interactions. And with all of these things, there really is a lot of overlap, but I think it's easier to think about them conceptually in sort of these different buckets. And as the title of the webinar implied, you can interact with people with intellectual and developmental disabilities in a variety of ways. As a victim, as a witness, as a defendant, and of course, as a colleague. You may have people that you work with, or you might encounter people in the legal process who are professionals with disabilities. So there's a lot of ways you might potentially interact with somebody. So in the communication bucket, here are some things you might look for. You might notice that somebody has a fairly limited vocabulary, or they might even have some difficulty with speech. So it might sound a bit different than you're used to, or it seems like it's maybe a little bit more difficult for them to express themselves using verbal speech. The person might show some difficulty understanding. They might not fully understand a different concept, something that you're saying to them, a system, regardless of what it might be. You might notice a shorter attention span. It might seem like the person just sort of on average just seems to have a shorter attention span than some other folks that you work with. You might also notice some mimicking or repetitive speech. So sometimes for people with autism, you might ask them a question and they might ask you back the same question, word for word. And you might be a little, surprised by that or taken aback. And again, it could be related to a disability. Sometimes we'll see nonsensical speech, so just speech that doesn't necessarily make sense to us. It may make perfect sense to the person who is using that speech, doesn't always make sense to the person who's interacting with that person. And again, we talked about some of the understanding. In addition to difficulty understanding, you might actually have somebody kind of bluffing greater understanding. They don't necessarily want you to know that they have a disability or that they just don't understand what you're trying to tell them. So they will just do everything in their power to kind of hide that disability. All right, the second bucket here, a general category of behaviors. Something that comes up frequently in the intellectual and developmental disability world are kind of indications that a person might be easily influenced or eager to please. And as prosecutors, where this might come up for you is maybe you're reviewing police reports of a confession and gosh, that confession just seemed pretty easy, and you might be a little suspect of it. And that certainly happens quite a bit. So for example, the Innocence Project reviewed this and they found that over 25% of those later exonerated after giving a false confession to police had characteristics of intellectual disability. So it's something that comes up a lot for folks with intellectual disability. They might just sort of be trying to agree with the law enforcement officer that they're working with, and sometimes that can turn into even a false confession. You might notice that the person gets easily frustrated. So perhaps, you ask them to fill out a form and, from your perspective, the form is really easy, but the person gets frustrated with it. Maybe they throw down the pen or the paper and they just say, I can't do this. That could be an indication that, it's something that is genuinely difficult for them, and it could mean that they have a disability of some kind. You might notice difficulty with some other types of everyday tasks. Maybe they can't tell you what time it is. Maybe they couldn't navigate transportation to get to your office. Whatever the case may be, you might notice some of those things in your interactions. The person might actually be using or requesting to use assistive devices, and assistive devices can be a variety of things. They could be things that help somebody with mobility, but they could also be things that help somebody with communication or for other reasons. And you might notice that. And sometimes, these devices look like everyday things. So some people use, for example, an iPad to help them communicate with other people and through typing. And we're seeing all sorts of technological advances that might not necessarily sort of trigger immediately that this could be related to a disability. And then this is something we mentioned previously. You might notice some repetitive motions or even some difficulty with mobility and moving around. Maybe the person in front of you is having a hard time holding the pen or picking up the form, things like that. It could potentially indicate the presence of a disability. Now, the last bucket here is interactions. And again, this can come up both around, the behaviors and the communication we were looking for earlier, but I kind of think of this as sort of like if you're in like a third-party standpoint and you're watching another interaction happening and you're not participating in it, some things you might notice. You might see some things that we would categorize as inappropriate with peers. So, let's say you're in a social setting and there's a person kind of, in that social setting, and maybe they're talking to everybody and they're going up to everybody. Maybe they're shaking everybody's hands. Maybe they're trying to, hug everyone. Like they're very overly involved. You might see sort of the other side of that where they might be under-involved, so maybe they're not talking to anybody. They're very much keeping to themselves. Again, you might see that sort of tendency to please or that over-compliance with authority figures when you're watching how somebody is interacting with somebody else, kind of always answering yes and really just answering in ways they think the person wants to hear. And you might also notice some of those challenges with social cues and social interactions, and really people's misunderstanding of what body language is supposed to mean or other social cues. Okay, so I want to talk next about disability rights. So people with disabilities are a protected class. So we're familiar with lots of protected classes out there, groups of people that have experienced marginalization, discrimination for a variety of reasons and throughout, our nation's history and the world's history. And so we try to now kind of address that through law and really try to protect people through law. And as prosecutors and other justice professionals, there are some affirmative obligations to actually uphold disability rights and to make sure that this class of people are being treated fairly and equitably with others. So I don't want to spend too long on the different kind of disability rights laws out there, but hopefully just enough to kind of pique your interest about kind of the laws that do exist. And of course, as we know of almost all types of law in the United States, we have law that's operating at the federal level that applies to almost everybody, and then we have law that also operates at the state level. So all the laws that are kind of listed here on the screen, the Rehabilitation Act, the Americans with Disabilities Act, Individuals with Disabilities Education Act, and the Developmental Disabilities Act, these are all federal legislation, but there are also state laws that address the rights of people with disabilities. So I just wanted to put that note out there. Now, at the federal level, we have some different laws operating. We have some laws that are operating because they are meant to increase services for people with disabilities, make sure that there are actually services and programs available to people. We have other laws that try to ensure that people with disabilities can participate in a particular part of life. And then we have sort of general civil rights laws. And so we can think of the Civil Rights Act of 1964 and the way that it was trying to prevent discrimination against people of color, and that led to a variety of other types of civil rights legislation. So really the first two laws on this list are civil rights legislation, the Rehabilitation Act and the Americans with Disabilities Act. So the Rehabilitation Act came out in 1973. Again, it was really following on the civil rights movement. And it was sort of the first time we had like a comprehensive piece of federal legislation that was prohibiting discrimination on the basis of disability. But it only applied to the federal government, federal contractors, and those who received federal dollars. So it left some people out, including state and local governments, which is what many of you are a part of as prosecutors. So in 1990, the Americans with Disabilities Act comes along, and it tries to fill some of the gaps left behind by the Rehabilitation Act. And so now it applies and extends the protections to state and local governments, but also private actors. And we'll talk a little bit more about the Americans with Disabilities Act in just a second. Now, the Individuals with Disabilities Education Act, or IDEA, is an education law. And what it does is it tries to ensure that youth or students with disabilities have access to an education, that they can actually get into the classroom alongside peers without disabilities, and that if they need some sort of specialized instruction in order to access education, that's what they get. And then with the Developmental Disabilities Act, this has been around for a long time, and it's gone through several iterations since the 60s, but basically provides services, supports, some basic anti-discrimination clauses, and also creates certain resources in every state that are specific to developmental disabilities. So let's just focus in on the Americans with Disabilities Act in brief. So I think this is the disability rights law that people tend to be most familiar with, but they're not kind of fully aware of all the different things it can do. So just a brief overview of some of the titles or parts of the Americans with Disabilities Act. Title I is actually all about employment, and this is the biggest piece of, kind of targeting private actors. Title I is really trying to make sure that people with disabilities can get into the workplace, and once they're in the workplace, that they can stay there. We have a really kind of challenging issue in the developmental disability world in that over 85% of people with developmental disabilities are unemployed. And that doesn't necessarily mean they don't want to be employed. We have plenty of people with developmental disabilities who want to be in the workplace, but for a variety of reasons, it's very difficult for them to both get into the workplace and then stay in the workplace once they're there. Title II, this is the one that really applies to most of you on the call today. This is the state and local governments provision, and basically applies to everything that a state or local entity does. Its activities, its services, its programs, kind of whatever you do, generally covered by Title II. Title III, this is really the title I think that most people associate with the Americans with Disabilities Act. This is the kind of places of public accommodation. So this is the reason that people with disabilities can get into things like hotels and restaurants and stadiums and theaters, places that hold themselves open to the public, and this better ensures physical access to those places. And then Title IV is really about telecommunications, and typically this means providing closed captioning services through kind of public information channels, and a few other things. And then Title V has some miscellaneous provisions that we won't necessarily get into. But again, Title II is really what we're going to talk most about today. Now, of all these kind of disability rights laws I've given you, or sort of the overview of them, I want to boil this down to two basic rights. So people with disabilities, when they're interacting with any kind of public entity or place of public accommodation, two basic rights. They have the right to, one, effectively communicate, and this means communication that is just as good as for those without disabilities. And two, they have the right to access on the same basis as those without disabilities to programs, services, activities. So those are really the two things we're going to be thinking about for the duration of the webinar, of how can we make sure that people with disabilities we're interacting with are receiving effective communication, and two, receiving access to programs and services. Now, on the flip side of that, if these things aren't happening, sometimes that's what can rise to the level of discrimination on the basis of disability. We're not going to spend too much time on that. We're really going to kind of flip it and keep focused on sort of the rights and what that might look like, and give you some tools and strategies that would help you both ensure effective communication, but also ensure access to programs and services. Now, there are a couple of tools that we typically use to kind of ensure these basic rights. One of them is, it's sort of the legal language, is the provision of auxiliary aids and services. This tends to be more commonly associated with effective communication. So a really easy example of this is, you're interacting with somebody who is deaf, and they use American Sign Language to communicate. You probably have to get a sign language interpreter to help you with your communication with that person to make sure that it's truly effective. The other kind of tool that generally applies to access to programs and services are providing reasonable accommodations and or reasonable modification to existing policies, practices, and procedures. And I know that's really a mouthful, but what it means is that we might have to tweak something about how we typically do business. We might have to change something about what we would typically do. So a really easy example is that, let's say that we have all of our interview rooms on the third floor of our office building, and it's a pretty old building, and there's no elevator access, and we know we have to interview somebody who uses a wheelchair. what might be reasonable in that context is to actually create an interview space that's down on the first floor that would be accessible to somebody who uses a wheelchair. And I think that's important because, again, we're talking about things that are reasonable. So, maybe some of you were thinking, oh, we'd have to build an elevator. And while that's certainly true in some parts and some pieces of when we're constructing new buildings and things, most of the time the law doesn't require something that's sort of above and beyond. It really just requires something that is reasonable. And we'll kind of talk more about what that can look like. Now, I did just want to give you one sort of example of what discrimination could look like in the criminal justice context, and I think one that's particularly relevant to prosecutors. And we'll talk more about this later, too, when we do our case scenario. So a lot of maybe prosecutors' offices have access to things like diversion programs, and, they might be diversion programs that are fairly robust and have lots of components to them. And sometimes what might happen is if you're encountering somebody with a disability, you might think they can't possibly do this diversion program. It's, if they have an intellectual disability, maybe you don't think it's the right sort of level for them to understand, or maybe it has so many components that are just really challenging. And, what disability rights law would say in that case is that, well, is there a way we could modify that diversion program to make it accessible to a person with a disability? And the disability rights law will ask this in a lot of situations, like, is there a way we could reasonably modify this, change this for somebody with a disability and still give them the same access as those without disabilities? And again, I think sort of the analogy to language access is really helpful here. Because again, it wouldn't be okay if we just said, oh, sorry, we can't work with people who speak a language other than English. We have to do something about it, and we can think about disability the same ways. Sometimes we may have to do something about it to make sure that both they can access the systems that we're working in, but also so we can more effectively do our jobs as legal professionals. So with that, I want to turn things over to my co-presenter, Chris, who's going to walk us through a case scenario.
So to illustrate the points made by Ariel, we're going to use a very simple case scenario. We could see the next slide. Can we see the next? Yeah. So here's the scenario. People respond to a call from Amy, a staff member at a local group home. She reports that one client stole something from another client. The alleged victim, Thomas, who has an intellectual disability, would like to file charges. The person accused of stealing, Marcia, has autism. Marcia has no criminal history. Marcia is arrested but allowed to return to the group home pending investigation. Next slide. So many prosecutors hearing this scenario may be hesitant to take the case or worried about taking the case. A prosecutor's only related experience with disabilities may be in trying to defeat defense claims of mental illness, which, as you've heard, is different from working with someone with IDD. The prosecutor may have no experience in interacting with people with intellectual and developmental disabilities. You may be uncomfortable or don't know how to proceed. But most importantly, you may have a pre-existing assumption about Thomas and the case. You may assume before you've spoken to anyone that this is a weak or improvable case. But we're going to give you just some very basic advice about a case like this, which is to treat it like any other case. Treat it like a prosecutor would do in every instance. Evaluate the evidence, assess credibility, look for corroboration. But in addition to those typical prosecutorial functions, it's useful to be aware of resources that may be available to help you, and also to try and get some additional information about Thomas's disability so that you can be prepared. There may be some defense attorneys on this call, I'm not sure, but if there are, the suggestions that we make are really the same for speaking with the defense attorney's client as it is for prosecutors speaking to their victim or witness. So when you think about speaking to Thomas, you want to make sure that you're able to communicate with him. There may or may not be an issue there, you don't know. And you also want to figure out how to evaluate his credibility. So next slide. some helpful strategies, and again, you should treat this like any other case. You should start by trying to speak with Amy, the staff member at the home, and the police who responded. This is something we would always do. They can provide information about the facts, and they can also give you some information about Thomas and Marsha's disabilities. Amy may also be able to provide some insights about how best to communicate with Thomas. So let's assume that you're now going to meet with Thomas. You've had these preliminary conversations with Amy and the police. And how do you begin? So our suggestion is that you, again, the theme is treat this case like any other. You should start by believing the witness. You should give the witness and the victim the benefit of the doubt. That is what we do in every case. That doesn't mean that we necessarily have to believe the person, but at least when you first speak to Thomas, start by believing him and give him the benefit of the doubt. Ariel has some additional strategies about how to speak with Thomas.
Great. Thanks, Chris. So let's say, you've done sort of your background research, you've reviewed sort of the other pieces of the case so far, and now you're preparing to actually meet with Thomas. When you first meet with Thomas, you can also ask Thomas what he may need, to communicate with you, to work with you. It's okay to ask that question of, is there anything I can do to help you feel more comfortable? Is there anything I can do to help convey information in a way that would be easier to understand? And to frame it like that. Of course, Thomas, as the person with the disability himself, will be sort of the best keeper of knowledge of things that will be most helpful to him. And he's gone through life having to understand sort of what things are helpful to him. So don't forget that Thomas is also a really valuable source of information. Now, the question was raised earlier about the impact of trauma and the impact of trauma on people with disabilities. And it certainly can look a bit different when we're talking about people with disabilities and then we're overlapping trauma on top of the disabilities. And there is some research and literature out there, particularly by Dr. Karen Harvey, that really looks at this intersection of trauma and disability, and specifically developmental disabilities. But certainly, trauma can impact anyone, and it can certainly impact somebody with a disability. And what that might look like in this context is that, it may be harder for Thomas to share his story, to get the information that the prosecutor needs conveyed to the prosecutor. In conversation, this might look like, Thomas is sort of telling things out of order. It might not be chronological. It might not even sound logical. And he might not be sort of just responding directly to questions that you might be asking as a prosecutor. And that's okay. Let Thomas tell the story his way, his own way, because that also can just really help Thomas feel a bit more empowered in this role. We know that, of course, crime victims, they're often feeling very disempowered, and they're going through a process that is incredibly complicated and can also be very traumatizing. And we have to keep that in mind, that we might have those things also layering on top of the disability itself. We also don't want to forget some of our basic communication strategies here. We mentioned earlier, you can stop and check for understanding, make sure Thomas is actually understanding the questions that you're posing, or if you're trying to convey certain concepts or information, you can pause and ask and have him explain back in his own words. You might just have to take some more time with Thomas. Sometimes time can be a really effective strategy. Giving yourself more time for the interview, actually slowing things down. You can speak more slowly. You can also give more time in between questions. Sometimes we talk about like a 7-second rule, that it might take somebody at least 7 seconds to fully process a piece of information you've given them. So that might mean putting more time and space in between your actual questions. Be careful with the use of jargon. Now, as legal professionals, we are often all guilty of this, of using language that is not necessarily everyday language, and language that can be legalese and might include acronyms and things like that. So we just have to be very aware of that tendency to use that type of language and try to use everyday or plain language instead. And we want to be careful with leading questions. So we talked about some of the characteristics earlier, and one of those might be sort of that eagerness to please. And if you're asking leading questions, you might be getting affirmative responses because that's what Thomas thinks that you'd like to hear, rather than Thomas actually kind of sharing his story and his experience as he perceived it. One other thing to keep in mind when we're talking about people with disabilities, and this certainly can come up with people without disabilities, but sometimes family members are heavily involved. There might even be somebody like support staff who work with Thomas who are kind of in the room with you or trying to support Thomas as he goes through this process. Depending on Thomas's communication needs, there might even be something like an interpreter. So just be very aware of who might be in the room when you're speaking with Thomas, or when your staff are speaking with Thomas, and do they actually have a right to be there, and should they be in the room? And I think that question looks very different depending on who we're asking. And I think one of the most common kind of questions or misconceptions that we get from family members is that if they have guardianship somehow in the civil space, that carries over into the criminal space. So we're often working with family members and saying that just because you have guardianship of your loved one in the civil sphere does not mean you get to make choices and things for somebody in the criminal justice context. So that's one of the most kind of commonly held misperceptions. Now, maybe you're thinking about taking this case to trial, and you're going to be working with Thomas to prepare him to even testify and really share his story. You might need to think about accommodations for him, depending on what Thomas might need. And one thing I want to tell you about are something called Americans with Disabilities Act coordinators, or ADA coordinators. Basically, every public entity that has 50 or more employees is supposed to have somebody kind of designated to be like the disability rights compliance person, somebody who's familiar with disability rights laws and can help the entity stay in compliance with those laws. So typically they're called ADA coordinators, and they can be found in all sorts of places, but most commonly in the legal system, they're often found in actual courthouses. But sometimes, it's a smaller community or it's more rural. You might have one ADA coordinator that's kind of working with all the public entities, and maybe they're sitting in the basement of City Hall somewhere, and you might even have a really hard time finding out who they are. But I would encourage you, if you don't already know who the ADA coordinator is in your jurisdiction or for the courthouses that you work in, that you try to seek them out, because these are folks that, again, can help you think through services and supports that might be available to Thomas, and things that we can do even in the courtroom to make sure that Thomas can really participate in the legal process. And let's say you are in one of those really small communities and there is no ADA coordinator, or you can't find them. Another great resource are state and local disability organizations. They might be able to help you think through potential accommodations. But again, don't forget about Thomas. Thomas, can generally tell you what kinds of things that might be helpful to him. You might be figuring out as your relationship continues with Thomas, things that are more helpful to him. And you can use that as a way of making sure that he has full access and can really participate in the entire process. And with that, I'm going to turn it back over to Chris.
So continuing the theme that we mentioned before, in addition to talking to Thomas, you're going to be looking for all the things that can either corroborate or contradict his claims. So you're obviously going to look to see, is there property recovered and from where? Are there other witnesses? What's the relationship between Thomas and Marcia, and so forth? But these are all standard prosecutorial efforts that we make in connection with any case, but that must be done here as well. Next slide. So let's assume that you believe Thomas, that you have a provable case, and you've now charged Marcia. What should be the fair and appropriate disposition for Marcia? And how do we take into account any public safety concerns? Now, in this fact pattern, public safety isn't particularly implicated, at least from what we made in our fact pattern, but it could be. But next slide. But in considering what the disposition for Marcia should be, a overarching thought should be, how do you keep Marcia from doing this again? And that can be done with discussions with the defense attorney, or the prosecutor can also formulate various solutions to that question. It could be as simple as a practical thing, such as keeping certain types of objects that Marcia may like out of her reach, or it could provide some kind of services or assistance in other ways. But in order to determine the best disposition for Marcia, you will also have to have some understanding of what her needs are so that the services that are provided to her are appropriate. Another practical consideration is what are the available resources. Some prosecutor offices are in jurisdictions that are rich in resources and others are not. So needless to say, a fair disposition will be dependent on what the resources are. And finally, again, the prosecutor should never lose sight of any public safety concerns there may be, and that has to be taken into account when determining what the potential disposition should be. But I'm now going to turn it over to Ariel again.
Thanks, Chris. So I think, when you're a prosecutor and you're thinking about potential, like maybe diversion options or services that would make sure that the defendant doesn't recidivate, that sometimes when we understand that the case involves disability, we kind of immediately jump to, we must, get them into a disability resource, and that's what we should be looking for. So one that comes to mind that tends to be kind of growing in popularity are things like mental health courts or mental health diversion programs. And again, I just want to reiterate that mental health disabilities are not the same as developmental disabilities, and the services and supports that those kind of two respective populations might need might not be very similar. So even though it might be sort of the initial impulse, you would really have to kind of ask yourself whether the diversion program that's specifically meant for mental health disabilities would be a good fit for somebody with a developmental disability. And most times the answer to that question would be no. But that doesn't mean that you have to just kind of go out and create a new service or program specific to people with developmental disabilities. You can, as Chris said, start by kind of thinking about what services and programs might already be available. And again, when we're thinking about disability rights, we think about reasonable modifications and getting a little bit creative, and we might be able to adapt or change an existing program to make it more accessible to somebody with a disability. So let's just take the example of Marcia. So Marcia has autism in this kind of fact pattern or scenario. And let's say that maybe one of the things that's difficult for Marcia is being around a lot of people. It's very overwhelming and she just doesn't do well around a lot of people. Well, let's say one of your diversion programs has a requirement of group therapy or kind of enrolling in a particular kind of group talk setting. It's possible you could just nix that requirement from this diversion program. That might be a reasonable modification that would make the overall program more accessible to Marcia. So again, we can just kind of think about, what existing program services do we have that are available, especially to somebody like Marcia who doesn't have a criminal history, and we want to keep this person from recidivating, and what could we do to possibly change it or tweak it a little bit to actually make it accessible to that person with a disability. Now, let's say you're in one of those places where resources are very scarce, or you just don't have a lot of diversion kind of programs or options, like formal options available. I also want to just tell you briefly about personalized justice planning. So personalized justice planning, this is something that was actually created by our state chapter of the ARC of New Jersey, and they've been doing this for decades now. But basically what they came up with is that, we can actually just look at an individual and create an individualized plan for that person that would help ensure that they get to stay in the community and they get to be successful, that they don't end up in the criminal justice system again. And the plan could cover things like, where is the person going to live? What kinds of services are they going to receive? How are they going to spend their days? Are there specific kind of services or supports that would help this particular person? So maybe with Marcia, some education about stealing things and what that means and what it can look like could be helpful for Marcia not to do this again, to take things from other people. So we can think about sort of the individual, what they need, and then surround the person with kind of a mishmash of different resources and programming that might help that person be successful. And, if you're curious about that, you want to learn more, there's lots of resources available on the ARC of New Jersey's website, but you can also reach out to me. I'd be happy to tell you more about it and how you might think about it for potential defendants that you might be considering programs like this for. And of course, you can also continue to work with state and local disability organizations, especially if you're doing something like personalized justice planning. Chances are disability services are part of that equation, and prosecutors are not, of course, going to be experts, and I would not ever expect you to be experts on disability services in a particular state or location. So work with the people who are state and local disability organizations that can help you get connected to disability services and other programs and things that might be available. And again, in every circumstance, this is not necessarily something the prosecutor is going to play a direct role in, but something you could certainly tell the defense attorney about or the defender, make them aware of it so that they can do the advocacy they need to do on behalf of their client. And then if you get a plan like this, sort of review from your perspective, you can think about, does this address your needs as a prosecutor of public safety and really preventing recidivism? So I wanted to just give you a brief overview of some of the different resources that are out there that might be helpful to you as prosecutors. But we're also getting close to the question and answer time of the webinar. So while we're covering this last bit of information, please feel free to start typing your questions for myself, for Chris, for Melissa in the chat box, and we'll turn to those next. So resources. So I mentioned that the ARC is an advocacy organization for people with intellectual and developmental disabilities. We actually have over 600 state and local chapters located across the United States. So chances are there is a local chapter near you, or at least a chapter in the state that could potentially provide you with additional information about intellectual and developmental disabilities in the state, the types of services available, et cetera. I also want to let you know about protection and advocacy organizations. These are often known as P&As in the disability world. These are federally funded organizations that advocate for people with all kinds of disabilities. Some of the things that they routinely do are investigate allegations of abuse and neglect, especially in institutional settings. They also have special access authority to kind of go into any place or program where people with disabilities are, and this can include visiting jails and prisons and doing things like wellness checks. But they also are experts on federal and state-specific disability law. That's really their bread and butter and what they're doing every day. So if you're really just looking for more information about legal obligations in your particular state, they can be a great resource for that, of what it really means to protect the rights of people with disabilities. A third group that I think we don't necessarily always think about as justice professionals are actually working directly with people with disabilities. Sometimes in the developmental disability world, we call these self-advocacy groups, or if we're talking about individuals, we call them self-advocates, people with developmental disabilities who choose to advocate for themselves and others. If we were thinking about this in the mental health context, these would often be called peer groups or peer organizations. But working with groups that are led by people with disabilities themselves, they could actually help you think through accessibility in your kind of office and procedures ahead of time. Let's say that maybe you're kind of playing around with a new way for a new form that you want people to be able to fill out. You could actually have a group test the form for you and give you feedback on whether they found it to be accessible or not, or a new process, or have them come in and test out your interview rooms. They can tell you about things like, gosh, it'd be really great if the lights were adjustable in here, or it seems really noisy, it's right next to the coffee room. Things like that we might not always be thinking about, but could help create a more accessible process in place. Pathways to Justice, this is a program that was created by the ARC's National Center on Criminal Justice and Disability and was piloted back in 2015. But this is basically our comprehensive kind of program to address access to justice for people with developmental disabilities in various communities. So we actually will go out into communities and create what we call a disability response team that includes legal professionals, including prosecutors, and a variety of other stakeholders who really care about access to justice in that particular community. And then as part of that, we also come out and do a full 8-hour training on intellectual and developmental disability and what it looks like in the criminal justice context. And as part of that, we also work with the community to create a plan of action for what kinds of things we might be able to do differently to make sure that people with developmental disabilities are interacting with the criminal justice system when appropriate, but when they are interacting with it, they're going through the system in a way that is really fair and accessible to them. They're really able to participate in that process. And then I'll turn it over to Chris to talk about one other resource that's been coming through Serving Safely.
Yes, we're going to be putting a lot of what was in this webinar in a white paper for prosecutors that will outline sort of basics about intellectual disabilities and developmental disabilities, mental illness, and various approaches that prosecutors can take in terms of dealing with victims, witnesses, and defendants. We'll also include some specific examples of programs that are initiated by prosecutors in various parts of the country.
And for the next 15 minutes or so, we're happy to take your questions. Please keep typing them in the chat box, but I'm going to turn things over to Tanya with the Bureau of Justice Assistance to help moderate.
Thanks, Ariel. Thank you again to Ariel, Christine, and Melissa for our informative presentation. As Ariel mentioned, we are now have started the Q&A portion of our presentation, and we would like to give everyone a moment to ask their questions. As I mentioned before, we do plan to keep all of our lines on mute mode. So if you have a question, please go ahead and start submitting them in our chat box on the right-hand side of the screen. I am going to go ahead and read some of the questions that have come in the order that they trickled in. So the first question, and this showed up during Ariel's presentation earlier, has there been much research on how to identify intellectual or developmental disability versus what might be indicators of trauma responses, or research literature about impact of trauma on folks with disabilities? Many of the behaviors you described sound similar to trauma responses.
Yeah, thanks for that question. So the short answer whenever we're thinking about intellectual and developmental disabilities in the criminal justice context is there is never enough research. It's something that we're constantly advocating for, and as Melissa mentioned earlier, it's something we're really pushing for in the Serving Safely initiative to create a national research agenda that would ask some of these key questions that we simply just do not have enough information about. So I'm not familiar with research that kind of distinguishes trauma versus developmental disabilities, but as I mentioned previously, there's more research happening about the intersection, about trauma and being a person with a developmental disability. And really the key person for that in the field is Dr. Karen Harvey. She does a lot of work on this issue, particularly in relationship to sexual assault, so kind of frequently focusing on victims of sexual assault in particular, and how trauma might manifest differently for somebody with a developmental disability. I think one of the most common things that we have to kind of be aware of is sometimes people with different types of developmental disabilities don't communicate verbally or might communicate in a way that's really just difficult for people to understand. So whereas somebody without this type of disability might be able to actually tell us about something that happened to them or describe their trauma in a way that it's easier to then work with them, we might not have that same sort of luxury, if you will, with folks with developmental disabilities, and they might be expressing their trauma in different ways through things that are interpreted as, say, problem behaviors, but it might actually just be a manifestation of trauma.
Thanks, Ariel. The next question is, does Title II of the ADA address misrepresenting benign DD characteristics as criminal? So, for example, the witness who experiences autism must be deceptive because he or she maintained poor eye contact.
Right. Thank you so much for that question. It's really a hot topic these days when we're talking about criminal justice and frankly, you know, the civil system as well. And people interpreting characteristics of developmental disabilities as something that might be suspicious or aggressive or hostile, or somehow indicate something that, you know, would not lend well to that person's kind of credibility or overall character. You know, of course, with any statute on its face, this issue is not addressed. and it's not addressed necessarily in the regulations either, but I think we're starting to see this more in arguments, especially by amicus in particular cases where disability organizations are starting to weigh in and say, hey, don't represent that, let's say a defendant is not making eye contact as like, gosh, this person must seem so untrustworthy. And I think we're also starting to see it more in the context of things like giving jury instructions and trying not to necessarily paint a picture of a defendant or another participant in the court process as something other than what might be characteristic of a developmental disability. So it's a very good question, again, not necessarily addressed on its face in the statute, but something we're starting to see more and more in the day-to-day system itself and weighing in as amicus on existing cases and trying to explain this to different participants.
Thank you, Ariel. A number of our participants expressed interest in finding more information regarding the research that you had mentioned earlier from Dr. Karen Harvey related to trauma and IDD. What's the best way to find that information and that research?
So what I can do is I can maybe put together kind of a short list of some of the resources out there. I can also put people in direct contact with Dr. Harvey if that's of interest. So maybe I'll just kind of name some of the key resources and I'll send that to you, Tanya, to maybe distribute with the webinar materials. And then if you're interested in maybe even having a conversation with Dr. Harvey, I'd also be happy to make that introduction. And she might be able to also point you to some additional resources.
Great. I have a question related to the ARC in New Jersey. Can you provide us an example of that state that has worked with defendants?
Yeah, absolutely. So one of the things that the ARC of New Jersey typically does is they will put together a personalized justice plan and then they will sort of make it a condition of probation. So they will kind of partner directly with probation services and put together this plan, and then they sort of agree that if the person is kind of meeting all the things in the plan, then the charges might even be dropped, or they will just have successfully completed probation for the potential sentence. So one of the things typically what they do is they connect people to services. So sometimes people just have never been identified as needing services, so they'll actually work with them, get them enrolled in things like Social Security and Medicaid to make sure they're actually getting services in the state. They'll also think through things where the person's going to live, what kinds of things are they going to do, and then they will help the person address particular challenges that might come up. So one of the examples that they often give is, a defendant who's supposed to come in and do sort of a routine check with their probation officer. What the ARC of New Jersey will actually do is they'll have a case manager who's assigned to that person, and they will remind them when it's time to do that check with the probation officer. Because one of the things we find is that people are routinely just forgetting things, like forgetting to show up for appointments, not understanding the consequence of that. So it could be something as simple as just reminding the person to check in with their probation officer, but it could be something as complicated as actually getting the person enrolled in developmental disability services.
Thanks, Ariel. The next question, are most people who have intellectual or developmental disabilities identified within the school system? Perhaps law enforcement or prosecutors could get access to records to find out if a suspect has a disability and may need special access or personalized justice planning?
So I'll address the first part, and then I'll let Chris maybe address some of the documentation pieces of this and maybe what she's done as a prosecutor in this situation. So as far as identifying people in the school system, part of the IDEA, the Individuals with Disabilities Education Act, is an obligation on schools to identify students with disabilities. So theoretically speaking, there is supposed to be this obligation to identify students who might have a variety of disabilities while they're still in school. But the reality is this doesn't always happen. And we have plenty of people who are now adults with IDD who were never identified as kids in the school system. We often see with folks who are, say, baby boomers and a little bit older that especially when they were school age, the common practice in this country and continues to be the practice in many other places was to institutionalize them, to put them in an institution, to not even have them go to school. So we also are dealing with some of the effects of that people might not have even had access to education because they might have lived in an institution most of their life. And now they live in the community, but we don't then have things like special education records to turn back to. So those are some of the challenges we see, certainly with identifying people with IDD early enough in the school system. And I'll turn it over to Chris to talk about documentation.
Well, needless to say, there are going to be many different rules in different states with regard to what documentation you can get and how. But you have to keep in mind that many of the records that you may be seeking implicate medical situations, so that you will need releases from the defendant or from the victim or witness who you're investigating. We're going to have a more comprehensive list of possible forms to use in the paper that we're developing.
Thank you. So the next question is, in your experience, how many cases have you had where the individual with IDD is sentenced to jail, and are accommodations made for them once they are placed in jail? Who in the system is made accountable for these accommodations?
So this is a great question, sort of like when do you catch people with IDD and make sure that they're actually receiving accommodations? And one of the things that we do with our Pathways to Justice program is we try to train professionals who are working at every point in the system, because the reality is, this isn't just up to prosecutors, this isn't just up to law enforcement, this isn't just up to correctional officers. The entire system kind of has an obligation to potentially identify and address the needs of people with disabilities who are moving through the process. So we routinely are working with all kinds of justice professionals to help them better potentially identify disability, but then, kind of follow through and what does that actually look like to provide accommodations to someone. What we've seen specifically in the jail context is that it tends to be a lot harder for people to be identified, just given the really kind of the frequent turnover that's happening in jails. People are there for short stays, they're there before trial, maybe they're there actually, serving a sentence, but there's a lot more turnover in the jail environment than there is in the prison environment. So we might see a little bit more identification of potential disability on the prison side, often not so much on the jail side. When people are screening for accommodations in the jail environment, they're typically looking for mental health disabilities. We have not seen a lot of screening tools that are specific to developmental disabilities. And the tools that are created for screening for mental health disabilities just vary very widely. There are some that are very comprehensive and others that are sort of just like, are you feeling depressed? So it can just really run the gamut of what do the tools actually look like. And of course, as is true of most of our system, it's just we have like almost no consistency across the board because most jurisdictions kind of get to do their own thing. So it's certainly an issue and certainly very challenging in the jail context, even more so than in the prison context. But yeah, what we tried to say is let's catch people before they get to that point if we possibly can, but it's not always possible.
Thanks, Ariel. So I want to do a time check. It's 2:13. We have a few minutes, and I do have a few more questions. I know that both Christine and Ariel have also provided their information on the slides as well, if you need to reach out to them directly if we don't get to your question today. But I do have time for a few more questions. The next question is, are you aware of effective models for DD screening in the criminal justice system, whether the person enters the system as a witness, victim, or suspect?
So I would just sort of, again, echo my earlier answer that generally speaking, no. I'm not aware of sort of any really good, strong screening tool. And I think, again, it goes back to the challenge of the criminal justice process itself is so complex and there's so many players involved that, we don't have a strong sense of like who is screening for this and when and why. And where we do tend to see the most screening tools or procedures happening is when at the point somebody is maybe entering jail or prison, and typically not happening before that. So it really is a challenge. So I think the other piece of this is that, we also don't want to encourage justice professionals to just sort of outright ask, do you have a developmental disability? Because, in certain circumstances, that could even maybe be something that's discriminatory. But I think what we do want is the system to better recognize, to better identify potential disability, and to better address those functional needs. And of course, if you are in a position where the person has a disability because it's been disclosed or, it's part of the case record, et cetera, then we're still also figuring out how do we address that in the system.
Thank you, Ariel. Did you both want to take one more question?
Sure.
Great. So the last question here is, have issues arisen regarding potential jurors with developmental disabilities?
I think that's really an interesting question. It's not something I'm very familiar with in terms of like people with developmental disabilities serving on juries and then having issues. I think what we would probably tend to see is if someone does want to participate in a jury, maybe they're disclosing their disability and requesting accommodations as part of their jury service. But I'm not really familiar with this issue. Are you, Chris? Anything around juries?
No. My guess is that during jury selection, if someone was concerned about that, it would come up then, just in the course of voir dire. But no, I'm not familiar with anything specific.
Okay.
Thank you to you both. Well, we have reached our time limit here for our webinar, and I want to just wrap up. Thank you so much to Christine, Melissa, and as well as Ariel for presenting the webinar today. And I want to remind everyone that we will send up a follow-up email with a copy of today's presentation. If we were unable to get to your question today, as I mentioned, the contact information for both Christine and Ariel is also on the slide, and you may reach out to them. We have recorded this webinar. We do plan to post it after today's presentation. So thank you to you all who have dialed in and joined us. And this concludes our webinar presentation today. Please enjoy the rest of your afternoon.